I can't entertain any mentioning matter because I am not holding any, assignment. Yes,
Any mention from the list? Item 1 to 10.
yes.
Item 7 and 15 active.
Okay. So, next
Tuesday.
Tuesday. Okay. Yeah.
Item 11 to 22.
Item number 12, Your Lordship.
Item
Maybe-
12.
Yes, Your Lordship.
Yes,
Maybe taken up next week.
next week. Okay.
Item 23 to 37.
Well, item number 23 may be taken up next week.
22.
23.
20?
3.
Okay. 20. Yes.
38 to 50.
Okay.
Item 1.
May I
Yes, sir.
please, Your Lordship?
Yes.
Petitioners filed this their misapplication challenging the cognizance order dated 7/3/2024
Yes.
against the present petition under section 498, 323, 506 of IPH and 4 DP Act. The petitioner is the husband of the informant. The marriage was solemnized 11 years ago, and out of their wedlock,
I'll issue notice because it is 498.
oh, bless.
498 issue notice.
I filed an IA.
Notice on IA also.
Okay.
Okay.
Item
Yes.
2.
Is there any chance of settlement?
Yes, there is very much possibility.
Shall I send it to mediation straight away? Explore the mediation and come.
Yes, yes,
If it happens, happens. Otherwise, we will see.
yes, yes,
Isn't it?
yes, yes.
I'll straight away mediation. Mediation. I'll fix the mediation. Take it. Okay. And the counsel for the petitioner undertakes to furnish the copy of the today's order. Send the copy of today's order to the respondents. You please send it. Okay.
Item 2.
My lord, may it please your lordship.
Yes.
My lord, the petitioner is praying before your lordship for quashing of the proceeding on the ground, and so also the order dated 28/2/2025,
Yes.
wherein my prayer for discharge has also been rejected. On the ground that your lordship, even if the entire prosecution case is admitted to be true, then no case can be made out against the petitioner. Your lordship may kindly see, there is an allegation against the petitioner as per Annexure 1, FR page 13,
Yes.
that her husband owns a house under OHSB. Now, the petitioner was required to, the scheme says the petitioner was required to disclose that her family member or any of either she herself or any of her family members owns a house. If any of the family members want to apply later on, this disclosure is required to be made. And they have prescribed a format wherein this disclosure is compulsory to be filed on affidavit. Now, page 13, your lordship may kindly see, my husband owns a house, it is not disputed. Thereafter, I have been allotted another house, not disputed. Later on, it is found that since my husband was allotted house, my house was cancelled, not disputed. Now, they have filed the case on the ground that I have filed a false affidavit. 420, 201, 200, it is the only case. There is no vigilance case, nothing. It is charge-sheeted under
But
400.
the initial FIR was for PC Act offense.
Initial FIR was filed. There is doubt that the staff of OHSB, they might have hands in gloves with me.
Okay, that 193, 200 and 420.
420 confined,
Okay.
because they could not get any track of any misappropriation or involvement of staff of OHSB.
Let us see the allegations now.
My lord, page 13, your lordship, last paragraph I am reading, part of the FIR.
13, 1-3.
1-3.
Okay.
At the time of submission of application, Sahana Jamal, this is the petitioner. At the time of the submission of the application, Sahana Jamal showed affidavit before the notary Harmohan Jana Bhubaneswar on 24/2/2003, stating therein that neither she nor her family members owns a house, shop, residential plot within the scheme municipality area. My lord.
Has made such false declaration.
False declaration and got
An
the,
affidavit using the true
my lord.
declaration.
Your lordship may kindly see, my affidavit I have annexed.
Where is that? Yes,
Annexure 3, page 25.
25, yes.
That is the second paragraph. That I have no any residential house plots of residential flat within the jurisdiction of Bhubaneswar. I have never stated, my lord. What has been stated that none of my family members, if this is my affidavit, they could have rejected my application. Even, my lord, it is a criminal case I am facing. Later on, they have cancelled my house, allotment of house. But if this is the thing, they could have rejected my application. It doesn't invite any criminal law against me. I have simply stated I have no residential house anywhere, and it is a fact.
Yes. Who is it? Yes.
Mr. Marana is your leave. Your lordship may kindly have a glance to running page 35.
35. Okay. Yes.
First of all,
Hmm.
they have obtained this house from BD, as read by my learned friend, that Orissa State Housing Board.
No,
So in this case, Orissa State Housing Board is the best person to say whether this petitioner applied rightly or falsely. So the learned code below,
Now, what is the, which document is the offense document?
yes,
Is it the affidavit?
affidavit,
The affidavit, he says that I don't have a.
not only affidavit, one format is there. So I am reading that.
So,
Your lordship may kindly peruse page 35.
35, yes.
The Lord Trial Court impugned order. I perused the case record. It reveals that the IO has submitted charge sheet against the accused petitioner of this case under section 193/200420 of IPC, and cognizance of the said offence has been taken on 9/4/24. In the said charge sheet, it is mentioned that the accused petitioner, namely Sahana Jamal, wife of Sheikh Ajiul Bari, at present Sasanda, PS Binjarpur, District Jajpur, submitted application
Yes.
for allotment of LIG house in the OSHB under
After
Dumduma housing
scrutinizing her application.
phase 4 Bhubaneswar.
Hmm.
After scrutinizing her application, house number LIB 453 was allotted in her favor on dated 14/2/20.
Yes,
Your lordship
time
may
of
kindly
application
refer
of-
to this
yes.
date.
Yes.
At the time of submission of application, Mrs. Sahana Jamal sworn affidavit before the notary, Haramohan Jena Bhubaneswar, on 2/2/2020.
Hmm.
She took possession of the house on number LIB 453 under Dumduma phase 4 under Dumduma phase 4 housing scheme on 31/3/2000. It is also further reveals that at the time of submission of application, the accused petitioner Sahana Jamal had also sworn affidavit before the notary Haramohan Jena Bhubaneswar on 24/2/2003, stating therein that 24/2/2003 that neither she nor her family members owns a house, shop, residential plot within scheme of municipality
No,
area.
but see, the affidavit at page
25.
25,
My lord,
dated,
that is before notary Harmohan Jana only.
date.
Date, your lordship, 24, it is 7 or something written, I could not.
Date is not there.
But it is before Harmohan
Date
Jana.
is not there.
Maybe Harman Jana, two affidavit also can be shown in.
Date is not there.
Because this is part of the charge sheet.
Yes, your lordship.
Same.
Yes,
Where is that?
that is,
See,
that,
it refers to two affidavit. One affidavit in 2000,
2000.
another
One
affidavit in
2003.
2003. Where is the other affidavit?
no, there is no other affidavit.
That's what he's referring to.
No, my lord, that is that.
No, see, he's referring to a particular date. Particular date.
At the time of submission of application, Mrs. Sahana Jamal sworn affidavit before the notary Harmohan Jena Bhubaneswar on dated 2/2/2020.
Now, this is
She
the
took
affidavit.
possession of the house number so and so. It also for
Where is that affidavit?
This is the affidavit, my lord. Annexure
No,
3.
that either this should be either 2003 or 2000, 2002 to
2
2000.
to 2000. Now, thereafter, if I took possession on some affidavit, that is a different, that is not part.
These are the disputed facts.
No, my lord. Your lordship, that is not the
Which
case.
affidavit you file all the document, I'll examine.
Let
No.
them avail all the document. Your lordship, annexure,
Your case, you got the charge sheet. Why don't you file the entire
page
charge sheet?
19, your
Your
lordship,
lordship will be
kindly see.
satisfied if your lordship peruses the impugned order which he challenges.
Page 19.
Entire discussions has been made.
And this is the affidavit. I am not disputing. Page 19, serial number 3, they have seized the file, and serial number 3, this affidavit is there. I have stated, my lord, it is a part of the charge sheet. I am not producing any document from my side.
Where is the charge sheet? Entire charge sheet you have not filed, sir. charge sheet along with document, then only I can ascertain.
My lord. This, but
See, there are so many documents attached with the charge sheet. Unless you place on record those affidavit or documents along with the charge sheet, how will I arrive at that conclusion? Then the findings, I have to go by the findings only now. The findings are against you. If you are doubting the findings, then all documents has to be there. You file the documents, I'll examine it. I'll put it next Thursday. Thursday, in any case, I'm sitting. File the documents. You have a case. If that affidavit is to be taken.
may I pray, my lord, let them also take, let them get the documents, because I have instruction that this is the document which has been.
You have got the charge sheet with you?
Yes, your lordship, that
Then
I have
file-
annexed.
File the documents. File the document next Thursday. Okay? Just simply urgent next.
Let your lordship also simultaneously direct them to get. I will produce, as your lordship has directed.
You also get the documents, Mr. Das.
Because,
Let us
yes,
see, yeah?
Documents, entire charge sheet charge is to be framed, my lord. The learned code below, your lordship may kindly only 1 minute.
Hmm.
I am taking.
Hmm.
It is the observation of the charge should be framed if there are grounds for presuming that the accused has committed an offense. The truth, veracity, and the effect of the evidence which the prosecution proposes to adduce are not to be meticulously judged. The standard of test of judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at this stage of framing of
That's
charge.
right. That's the general.
Nobody disputes
Exactly.
that.
So, his charge is going to be, I think, charge.
No, the only question I want to know is if the entire case hinges upon that particular affidavit.
Yes, your
The
lordship.
language of that affidavit makes it clear that he gives a declaration that I don't own any property.
They should have.
Might be the family members might be owning the property.
Yes.
If that is a condition for rejection, it could have been rejected. That's a different consequence altogether. But if on the basis of that affidavit, if you are prosecuting
Yes.
someone, and that affidavit has to be read.
Yes. She has obtained another house by stating falsely in the
That's what I want to
That-
know. Where is that?
That is
Or
admitted, my lord. I am admitting that my husband owns a house.
Please file those documents. Let us
Yeah.
see. Thursday, next Thursday. Yes, next.
Item 3.
My lord, your lordship.
Your
is putting
lordship, I put
Next
it
Thursday?
to the week commencing from 21.
21 लोग.
Mr.
Week
Maharana
commencing.
might have come.
21 July.
21, हाँ,
21 July.
हाँ.
No, 21 जुलाई बहुत लेट ही है. तो चार्ज
ना,
का फ्रेम में चार्ज फ्रेम के लिए पूरी दिन नहीं.
Charge was the frame है ही सही रहने की.
No, no, no.
No, your lordship, I fix it to 7th or 14th of week commencing.
No, week commencing na go date रे आसो. Say that document verify ହେଇଯିବ. जब थिबा I have to face the trial. I don't.
Let it be on 10th, huh? 10th Thursday.
Yes.
Because Thursday, generally I may sit in Thursday.
Yes, your lordship should hear this.
Yeah. And your lordship, I will also produce. Let them get
You
all.
produce because it is your case. You produce. They
We
will
will
bring.
direct-
He is holding all big file. That's it.
Let them also produce. I'll produce whatever documents I have.
Yes.
My lord.
Yes.
Obliged.
Item 3.
Item 3.
On 10th, my lord.
Yes, 10. Yes, yes, Mr. Naik.
May I please, your lordship?
Yes.
This is a cognizance order I have challenged lordship. Very interesting point involved lordship. The complaint is filed in regards to the sale of the property. I am the purchaser. Now, while cognizance was taken, no documentation to that effect that regarding the sale deed to ascertain what was the exact liability against me, lordship, for which cognizance was taken, I have challenged. Squarely, this aspect has covered the judgment of.
Let us see what are the allegations because it is a complaint case.
A complaint case.
Let us see the allegations.
A bouncing of check, allegation is lordship immediately
It's a 138 cognizance.
Yeah,
Cognizance under 138 and
lordship.
Let us see. What are
About
the-
page 8.
8. Okay.
The page 8, the factual aspect of the
Mhm.
case. Facts of the case, lordships.
Mhm.
Lordship got it, page 8,
Yes, yes.
facts of the case. I am not going there.
Mhm.
On the operator. The complaint and others have executed RST number so and so 2023 with the accused, with me.
Hmm.
And another Sathak Das to sell their land, which is on consideration of 3 crores 85 rupees, out of which the accused had paid 47 lakhs, 3 checks I have given.
Yes.
This is what they are saying.
For the purpose of purchasing the.
Sell deed was made, I have sell deed, as per sell deed I have paid. Now they say, this is the whole dispute. Sell deed was on 1 28/8/2023. Check was to be deposited on 1/11/2024. Lordship, on the top.
Yes. I saw.
28/8/2023. Register said it, they have accepted the money, as per their statement, register said.
You simply tell me whether you have issued the check or not.
Yes, I have issued.
It got dishonored.
Got the journal. Yes, Lordship. My
It was
point,
paid for towards what liability and all that will be decided in the trial only.
that has to be before taking cognizance. Learned court should see what is the exact liability against me, Lordship. Now, Lordship, kindly see the documentation. Page 11. Page 11.
Yes.
Squarely covered, this aspect squarely covered Honorable Supreme Court judgment. I have got that judgment.
Where is the 138 notice granted given to you? Have you replied to that? Have you replied to the notice under section 1?
No, I did not get a chance to reply to that.
Why? You received it.
They say the document out of 3, they find the postal tracking of the 1 that is served. 2 they have not served to me.
No,
Out of 3.
come to page 4 of the complaint. Para 5. The complainant issued legal notice to the accused person through his advocate on such and such day with AD and all. The accused have received the said legal notice on 20th November 2024 and which is ascertained from the postal tracking report, but has not taken any step towards dispensing the
This in
liability.
regards to 1 check. They said 3 checks were bounced.
I don't know where is that legal notice.
Legal notice they have not annexed here. That is what I am saying, Lordship.
Your petition, you have done it.
That is what. And kindly see the page 11. Page 11.
Now leave it here.
Page
You have to
11.
face it because see, there are 138 cases.
Page 11, Lordship. Page 11, there is no cell deed. That is-
All these things are dispute to be decided in the trial only.
No, no.
It is a cognizance stage.
Because Lordship, what is the liability? That is what I am saying. There was no liability. What I am before my Lord, I have paid.
Liability or no liability, that will be decided in the trial only, not in the cognizance stage. Cognizance stage.
Kindly see the judgment of this Honorable.
Yes.
Supreme.
Okay.
This is very interesting. This is different in sale and purchase of the land.
Yes.
Page 3 of the judgment.
Yes.
Be read.
Yes, please read it.
In our view, the offense alleged was that a check was given towards consideration for purchase of a property. Neither any document was produced on record, nor there was any evidence that any convenience was executed in favor of the appellant. Thus, the submission of the appellant that there was no.
But here is a case where the sale consideration was given through check and the sale could not be taken place because execution of sale deed was not done. So therefore, it is not executable. That's what the court said.
20
And in your case, it's the reverse thing.
20
Sale has already been executed. Sale deed has been executed.
23 I have paid all the amount.
You have paid the check towards the sale consideration. See, the sale transaction is taken.
Why I am saying, Lordship answered me one question, whether you have given the check. Yes, Lordship, I have given. They check, they did not return to me.
Why
That is-
sale consideration? Why should they return to you?
Already I paid the money, considered it's money.
Well, those are the facts to be determined in trial.
But already
In lieu of the check which you have issued, whether you have paid the money.
in a good faith has turned into
Ah.
a bad faith. Lordship, what can I do?
Good
I have
faith.
paid-
See,
Lordship,
Mr.
I
Nayak,
have paid more than 3 crores 20.
try to appreciate. Good faith or bad faith is the factual dispute that has to be determined.
Lordship, let them bring the documents, send it and everything. What is the liability against me? Only that point. Before taking cognizance, learned judge should consider this aspect. How much liability? Merely issuing they did not return my check. Now they enter with the send it. I am in trouble. Lordship, kindly see that.
This judgment doesn't say that at the time of taking cognizance in a 138 case, the court has to give a finding whether the check issued
But
towards a legally recoverable debt or not.
what say only documentation? Kindly come to page 11.
Yes.
There is no send it. knowingly they have suppressed in the complaint. Complaint petition, page 11.
Yes.
Documentation lordship achi.
Hmm.
There is no document, send it. Why did not they annex this send it in the document? What made this honorable learned judge?
That's good for you.
Learned judge to
That's
proceed-
good for you. They are not filing some document which
But-
may be incremental.
should take it cognizance, lordship. And I have also appeared there. Not that I have come defeating the procedure. I have appeared there.
I'll pass the order.
Lordship, only interpreter, let them bring the records, the complainant.
Your case is it's a cognizance taking at the stage of cognizance in a 138 matter. You want to stress. You want to pull.
Lordship, already paid everything, Lordship. Now I can I deprive of being not getting justice from
Where
this,
from I'll get that you have paid towards the check amount you have paid. Show me.
No,
One I'll issue notice.
consider the amount. They have stated, consider the amount of.
What is the case is? Try to prove. Case is you have given the check
Lordship.
towards the sale consideration. And before the check was presented, the sale deed was executed in your favor. Subsequently, when the check was deposited, it got dishonored. That is the case. And how can see you are doubly benefited. One thing you take the land also,
No.
you are given the check, it got dishonored. These are the facts.
No, Lordship, my lords, experienced Lordship. I have till now I have not given.
I have not purchased any land on this.
Till now I have not got the possession. And now
I don't have an experience of purchasing land this way.
I am not going to that arena.
Anyway, leave it here.
Lordship, only issue notice. Only issue notice. Let them bring the document because case is check.
I can only help you in one way, that if you go to mediation and pay the money.
Mediation. Let the mediation. It will be decided.
Decided, nobody is going to decide the case. You have to pay the money, that's all. You don't have money, you installment or something, you pay.
ସବୁ ଦେଲି ତାଙ୍କୁ ଆଉ କେତେ ଗୋଟେ ladies କୁ ଫେଚ କରିକି ମୁଁ ଯାଇକି ସବୁ କଥା ହରେଇକି ମୁଁ ଆଉ କଣ କରିବି?
Then you have to tell her that I have already paid, leave it here. That's, see, legally there is a case against you. What to do? You might have paid, I don't know.
This is my
Issue notice to the opposite party. Number one, limited to the question of exploration of mediation. Okay, I'll refuse.
till then next date that ରହିଛି ଖାଲି ସେ ଆସିଲା ବେଳକୁ
No, please. I am giving next Thursday. Next Thursday. You file the process. Next Thursday, I'll take it up and pay. No problem. You are not going to be hanged on that day. Don't worry. Next. I'm just giving indulgence to that extent. Only limited to the question of exploring the possibility of a settlement. That's all. Yes.
May I please, Lordship, ma'am?
Yes.
Here, my lord, the quashing of entire criminal proceeding for the commission of offence under section 22 BC of 22 BC of NDPS Act, my lord. 22C of NDPS Act, my lord. But allegation is that, my lord, on the date of alleged occurrence, 3 motorcycle was carrying 3 bags of contraband articles. While seeing the police patrolling party, they threw the motorcycle and fled away from the spot.
You are one amongst them.
No, I am coming, my lord. Now, my lord, the police traveling on that way, some local persons asked about this absconded accused, and they 2 of them named my name. In this way, I have been implicated. I am not that people of that area, man of that area. This incident was occurred in the place of Baudh district, my lord. I am a man of Bausuni PS, near about 25 kilometers away from that spot, my lord.
Yeah.
The motorcycles which has been also seized by the police, that motorcycles were on different names, my lord. The motorcycles, I am not the owner of that also.
Recovery,
motorcycle.
how much?
Recovery, my lord, that is 3 bags, my lord.
30 kg and another 25 kg. Okay. 55 kg.
55 kgs, my lord.
Yes. Good case for bail.
In the
Not
meantime,
purpose.
my lord,
Very good case
But
for
I-
bail,
but I
not
pray, my lord,
purpose.
my case is that, my lord, if my lord, the motorcycles has been in my name, then
But
matter could
at
have
the-
different.
at this stage, Wasik is not.
And
I don't think quashing possible.
Your lordship.
Good case for bail. Have you got the bail or not?
No.
You should get there. The
In the
antecedent-
meantime, my lord,
what
in the
about
meantime-
your antecedent?
In
How many cases?
no case, my lord.
You get the bail. What
In the
is it?
meantime, my lord, cognizance has been taken, NBW has been issued.
I'll stay the NBW, you go and appear. I'll stay the NBW, go and appear, resort to the remedy, you will get the bail because 55 kilo and no conscious position.
May I
You'll
pray,
get the bail. What is the
may I
bail?
pray one thing, my lord? Your lordship may issue notice to the state council. Till that date, my lord, if your lordship will satisfy that, no, otherwise, my lord.
I will stay. See, I'll stay the execution of NBW and give you an liberty to go and appear and resort to the remedy available to you under law. And you have a good case on merit, you will get the bail. This is what, isn't it?
Your
Let him
lordship-
go and appear because see, 55 kilo, no conscious position,
Your lordship.
and there is no antecedent. He should get the bail. Huh?
Said hubble. That cannot be
But
possible.
that's
That cannot be possible. Your lordship also knows that.
guarantee you.
Your lordship also knows that
Where
position.
is that? Where is that NBW thing?
That is, my lord, at Annex 2, page
14.
14, my lord.
NBW. You, what is your name? Sujit. What is your name? Sujit.
Sujit Khatua, my lord.
I'll stay the execution of NBW till a certain date. You go and appear.
May I
That's
pray?
the best
Your-
thing I can do.
Your lordship, if your lordship will not allow me to, interim order, your lordship.
That's the
will
interim
not-
order. I'm saying the execution of NBW for a certain
But
time.
problem is that,
That
my lord,
itself is the interim order.
but problem is that, my lord, I will not be granted bail. I know that, my lord.
It's not a case for quashing. You know that. What best I can give you is you go and appear. What was the date for appearance? 21/6/2024. You didn't appear. I'll give another 15-20 days. Go and appear.
Your lordship may simply issue notice so that if some material is available, your lordship will find, then I have no case. If your
Why to keep pending? Today you are going to get something. Tomorrow it will be dismissed.
no,
At least get something and go.
no, I have large hope before your lordship that I can.
I'll issue notice that neither here no interim order can be passed.
Not necessary, my lord. That
Simply issue notice.
Hmm.
Okay, issue notice.
your lordship fix a date, my lord. Otherwise, any
Issue
date your
notice
lordship.
and after 15 days go ahead. Yes.
Item 5,
But it's better that you should. I'll give that relief. Go and appear and
At least I will take.
let the things start moving.
At least I will take a single chance if, my lord, some material, further material will be available before.
It is already there. Yes.
That statement also is not available with the police record, my lord. Who has said my name? Only.
So that's why I'm saying it is a good case for bail. You can convince the court in
Then
that
how,
case.
my lord, the cognizance has been taken? If, my lord, the statement of that witnesses is not available with the record, then the magistrate has to, the Lord and court below has to verify that. That is my submission, my lord.
I'll do one thing. I'll pass appropriate order which will suit you as well as the prosecution. Okay. I'll pass appropriate order which will suit you as well as the prosecution. Okay.
My lord. Till that date, matter inevitable.
I'll do the needful. Don't worry. Yes.
item 5,
Here, my lord,
Yes.
I came here
5.
before your lordship. So only for a first time and second half order, because it's a case under section 109, that is 307. Allegation is that 10 to 15% enter inside the shop. They have given fist and kick blows to the informant,
Your bail application rejected.
rejected, and other co-accused person have been granted bail only
Where
because.
where is that rejection of bail
My lord.
application? So
Only because we have 2 to 3 antecedent of the year 2014-15. My lord, our bail application was refused.
and who has got the bail?
My lord, that petitioner number 3 and 4.
It is an anticipatory bail.
Yes.
You apply for what do you say?
First half, second half, parity.
Parity as it is he has, because I don't know what is the role attributed to him. How many of you are there?
My lord,
5 persons.
my lord, this is the allegation, my lord. See.
Hmm.
ଦୋକାନରେ ପଶି ଅଜିତ କୁମାର ପାତ୍ରଙ୍କୁ ମୁତ ଲାତ ଗାଲକୁ ଚାପୁଡା ମାରିଲେ. This is the only evidence.
Investigation is over.
No, going on.
Any medical evidence, anything?
109 is there, 307.
Yes, that is 307.
307, but let us see what are the injuries.
There is
Injury
no-
matter.
What is the weapon used? Nothing.
No, nothing.
No
It is-
weapon used.
There is not with us. That what is the
First of
Which
all, very doubt kichu mu magun. This is the when currently see page 11. Border for fifth line. 10-15 ଜଣ ମିଶି ଦୋକାନରେ ପଶି ଅଜିତ କୁମାର ପାତ୍ର
Where is the statement of injured?
the injured statement, that is the
Show me the injured statement.
injured statement is not that is the
No, show me the injured statement. Because it is your application, anticipatory bail application is rejected on the basis of the statement of the injured. That means you have the statement of
Yes,
injured.
I
You have filed-
am not with me, but he has sustained one injury on his leg.
No, vital part. That's what
No,
the
not-
court
not-
gives the finding. See, taking note of, it says,
Vital part means that is leg, my lord, the injury report.
no, it says that the court perused the statement of the injured and injured report, and which indicates that one of the injuries is on the vital part of
That is
the
on leg,
injured.
man. To be honest, that is on leg.
Where is that? Where
Sit
can I
down.
get it? Where can-
First half, second half,
No, I have to read it because see, there is an order by the
that
court.
is order,
Reject-
that was
reject.
reflected.
Next,
that was-
next.
allegation ରେ ତାର ତଣ୍ଟି ଚିପି ନିଶ୍ୱାସ ରୁଦ୍ଧ ହେଇଗଲା ବୋଲି ସେ that's why
Is there, do you have the statement?
no
That is the
FIR
story.
FIR, no, statement of the
copy is
with-
not with us.
injured.
No,
Next Thursday, next Thursday.
Item 6.
May I please?
Yes.
One of the petitioner in this application for passing of this case is on the ground of amicable settlement between the
What are the offences?
386, 34 and 25, 27 of arms act matters.
Have any judgment?
Mercy.
In these kind of cases can be quashed.
That only as per the case and FIR story, the 386 is not made out against the present petitioner, Mercy. Because the admitted it is fact that the present petitioner along the present informant other 9 numbers of including the witnesses are taken a Balighat at Hatadhya, and present petitioner is a shareholder on this Balighat. When the present petitioner demanded his money back because he is not interested to take a part of the Balighat, then the case is initiated, Mercy. Neither the section 20.
What is the recovery?
Nothing, Mercy. We already know.
Arms Act is there, no? What?
Arms act allegation, no recovery of gun, Mercy.
Without recovery, how can they invoke
As per the
25,
story,
20?
the other goons are showing them guns. This is the case. Other
the
goons,
gone. There is no license.
other goons are showing the
Show
gun.
me any judgment if I can quash. Then only I can.
See, if the section is not made out, then
No,
and-
it's
and
not.
the
It's not.
party are amicable settlement matters.
Settlement doesn't mean that. Therefore, I'm saying,
Well-
show me any judgment in
Well-
Arms Act and 286 on the
Because-
ground of settlement. I can
Maharaj, because the Arms Act and 386 not made out against me.
merit. Are you interested to argue on merit? Then I'll get
Maharaj,
into merit.
then I'm
Settlement is different issue. Merit is a different issue. If you want to argue on merits, it's all right. Argue. I'll just
Man,
look
come with the judgment, Maharaj, I'm ready with the judgment, Maharaj. As per Maharaj, I'm ready with the
get
judgment.
some judgment.
Maharaj,
Get some.
but Maharaj, this is a non-compoundable offense and all is depend upon Maharaj only direction.
Non-compoundable offense. Therefore, you are here
Maharaj.
under 482. Otherwise, you would have gone under 320.
Maharaj.
Obviously, but get some judgment to.
Yes, Maharaj.
Moreover,
Next Thursday.
3 antecedent also against the petitioner. That is the.
Maharaj,
That's the
Bali-
problem. I've seen it. So get armed with some judgment now.
Maharaj, as per the fact, it is very clear, even if the informant is admitted, even if the others, other witnesses admitted that the petitioner is the partner of a Balighat, then suddenly some dispute arises and petitioner is demanded his money back. And then the case is arises, Maharaj.
Yes. Okay. Good.
Maharaj, kindly fix the date, Maharaj.
Next week. Huh? Yes.
Maharaj, my submission will be recorded that I am submitted that already the amicable settlement is there, Maharaj.
You have written in the petition.
Yes, Maharaj.
Then-
I am written in the petition.
Why should I record submission in the petition?
Maharaj.
Are you doubting?
No, Maharaj.
Item 8.
Oh, bless Maharaj.
May I please, Your Lordship?
Yes,
I'm DC, my lord.
yes, yes.
My lord, petitioner challenging the whole criminal proceeding, my lord. On the ground, my lord, that the case is arising out of a civil dispute. Both the petitioner and the informant, my lord, the co-share of civil one of the disputed land, my lord.
Mm-hmm.
On that basis, my lord, the dispute has been arised. If you see the Annex 2, my lord, one interlocutory application has been passed by the learned civil judge senior division that has been passed in favor of the petitioner. But
Yes.
subsequently, my lord, some dispute arose between them. Then, my lord, the case has been fostered.
What are the allegations? Let us see.
Allegations,
What
my
are the-
lord.
Hmm.
Allegations are, my lord. Officer section, my lord. 126(2), 115(2),
No,
296.
no, forget about the sections.
Yes, my lord. Allegation is that, my lord, they on the disputed land, the
Yes, have you implemented them? Yes, I issue
Yes,
notice.
my
huh?
lord. Yes,
Issue
my lord.
notice.
Grateful,
Notice to party number 2. So I have notice for the state. Yes, next.
My lord,
Item nine.
I as in file, my lord. Only paper status,
That
my
too,
lord.
I'll see. Let them come. Yes.
Yes, my lord.
Item
Grateful, grateful.
9.
Item 9 man permitted to order matters in infructuous.
Matter is becoming infructuous. Yes. 10.
Item 10.
May I please? My lord.
Yes.
My lord, this is matrimonial dispute, my lord. My lord, offense under section 498A, my lord.
Hmm.
My lord, what happened, my lord? My lord, the petitioner is a daily labor. He was working at Bangalore.
I'll issue notice 498. I'll
Okay.
issue notice. Issue notice. Yes.
Item 11.
Oblige.
Respond.
Deep oblige.
Respond.
First state. I file करता
I on notice on file. Huh? Yes.
Oblige, my lord.
Yes.
May I please, Your Lordship? My lord, the petitioner has filed a petition under section 528 of BNS, my lord. It is purely a commercial dispute, my lord. Prior to filing file the register the FIR, initially the informant has filed a consumer complaint, my lord. And Lordship have a glance to order of the consumer.
Let us see what are the allegations.
Yes,
Yes.
my lord, that is the allegation against
Come to page 14. Complaint. 15. Let us see 15. Read it.
13, 14.
Page 15.
Yes. ମୁଁ ସେ ମାନସ ରଞ୍ଜନ ଭଞ୍ଜ ପିତା ସୁଆଂଶ ଲିଖିତ ଏତଲା ଦେଉଅଛି କି ମୁଁ ଏଜିଏମ୍ ଇନ୍ସପେକ୍ଟର ଫାର୍ମର ପାର୍ଟନର ଅଟେ ଉକ୍ତ ଫାର୍ମର 2ଟି ଟାଟା ଟ୍ରକ୍ ଯାହାର ରେଜିଷ୍ଟ୍ରେସନ ନମ୍ବର OD 19Q5318 ଓ OD 19L 3918 ଯଥାକ୍ରମେ 20/7/20 ଏବଂ 9/1/22ରେ ଆକ୍ସିଡେଣ୍ଟ ହୋଇଥିଲା। ଆମ୍ଭେ ଆମ ଫାର୍ମର ସମସ୍ତ ଟ୍ରକ୍ ଗୁଡ଼ିକ ମେଣ୍ଟେନାନ୍ସ टाटा मोटर्स ऑथराइज सेंटर देहुरी मोटर्स परजंग ठारे करुथोर आमे उक्त 2टी एक्सीडेंट गाड़ी मरामती निमंते उक्त देहुरी मोटर्स रे मरामती करिवा पाई उपरोक्त गाड़ी 2टी को यथाक्रमे 21/7/20 और 10/1/2022 रे देइथिलु। उक्त समय रे आम्भ मध्यरे कथावार्ता होइतिला जे उक्त गाड़ी को 1 मास मध्यरे मरामती करिवे जदि 1 मास रु अधिक डेरी हुए ताहले से गाड़ी 2टी को हस्तांतर करिया पर्यंत प्रति मासरे गाड़ी गुड़िकर EMI देबे एवं से
Next, page 16. Next paragraph.
yes
किंतु
दुख परितापर विषय है कि उक्त देहुरी मोटर्स ओनर मैनेजर अदर स्टाफ माने आमे जेते थर गाड़ी आनिया पई गले मध्य आमको उल्टा धमक देउछंती तुम गाड़ी विषय आमे किछि जानि ना बोली कहउछंती 19/25/24 मो स्टाफ विकास विश्वाल परजंग किछि तार पर्सनल काम रे जाइथिया जोगु फेरिबा समय रे देहुरी मोटर्स
this
भीतर
is the offense. This is the offense. The
Yes.
earlier part is conjugal dispute.
Well,
This is the offense.
that is the offense.
Assaulted, scolded,
Yes,
destroyed the vehicle.
that is the allegation of the informant.
At this stage only allegation.
Only allegation against the petitioner is there. They are assaulting, they are threatened, they are going, they are concerned, they are threatened. But Lordship, have a glance to page 19.
19, yes.
It is the letter of the complainant, a letter of the informant, letter of the petitioner, my lord, to the informant. Prior to this letter, continuously series of correspondence made between the parties, my lord. To take back your vehicle, we have already invested, we have already repaired your vehicle. You take back your return.
Where is the vehicle now?
Vehicle, my lord, continuously when the informant did not accept the request of the
So you have
petitioner.
taken and spoiled it.
My lords, continuously they have not received.
Not received means you should have kept it in your
How
workshop.
since 20 to 24?
Therefore, they have not taken their car, which they have given for service. Since you have asked them to take it, they have not taken. So therefore, you have broken the car.
My lord,
And a video is prepared.
My lord,
And when they came and you say that
my lord, some money has. It is the understanding. The repairing of the vehicle within a month. After 1 or 2,
everything is consumer dispute, no problem.
My lord, there is
But
a,
once the
my lord, garage problem, security problem.
therefore you destroy the car.
Continuously we have intimated, my lord. But they have not
Suppose
taken.
they haven't come.
My lord,
That doesn't mean that you destroy the car.
How days how years they together he will kept it.
That's a different story. You have intimated and you prepare a video also for that.
Yes, my lord, we have intimated continuously.
Intimated that we are destroying your car since you are not taking it.
No, I have
Very slowly.
intimated you pay our repairing fees, repair charges, and take back your vehicle.
If it doesn't happen, then what?
My
you
lord,
should have
that
done?
is a time limit. They have stated, they have request within a month you prepare. Otherwise, you will pay the EMI.
Where is that kind of limitation is prescribed? You tell me. You have to take it for any reason. Somebody has given you the car for the purpose of service.
Yes.
Something happened. He is not satisfied on the service which you have provided, and at the same time you raise the bill. He is not paying the bill, and you told that you take back your car. He is not taking the car. That doesn't mean that you will spoil the car.
My lord.
Break the car and prepare a
Yours-
videography and photography and send it.
My lord, here
Now you don't take the car, take the photo.
it is a purely commercial dispute, my lord.
Not commercial.
Lordship, have a glance to the consumer court order.
Second part is the problem.
My lord,
First part is
prior to registration the FIR, they have filed a consumer case, my lord, and claiming for 3 lakhs in compensation. That has been rejected. Thereafter, he lost the.
that is regarding the service, but you have the
My lord,
vehicle has to be given back.
It is purely commercial. If he has demanded the money, how much will spend for repairing charges? That will be deducted. And
Repairing deficiency of service is one issue. Consumer court will take care of it, and they have approached, they've lost it. But you have to give back the vehicle to them. Where is the vehicle?
My lord, the cost of the vehicle, whatever he will. Whatever the demand, he will the cost of the vehicle and whatever the amount we have expensed in the repairing charges and garage charges, then matter will be disclosed. It is purely commercial dispute.
Where it will be? Consumer court gone.
Consumer, he failed in consumer court, my lord. He failed.
But they have approached the consumer insofar as the deficiency of service is concerned.
Yes.
That was rejected. But today the question is, where from they'll get their vehicle? Unrepaired vehicle, damaged vehicle also. Where from they'll get it? They can go to insurance company. They can recover.
Their cost of the vehicle, we must refund the cost of the vehicle. After deducting the repairing charges, we must refund. Whatever he will charge, the cost of the vehicle, if he will demand, then we'll pay.
Now your subsequent conduct is difficult. Yes, sir. What do you say? You settle the dispute, I'll issue notice.
Yes, ma'am.
Settle the dispute. Issue notice, opposite party notice. Give back their car and wait whatever they.
Notice will decide.
What is this? You can't damage the vehicle like this.
Years together, he is not. If he has some interest over his vehicle, he must come within a year or 2 years. After 4 years, he will not listen the request of the company.
You should have sold it, record money. Why have you spoiled it? Anyway, we'll see.
Item 13.
Obliged.
Please, Your Lordship.
Yes,
Your
madam.
Lordship, on this matter, Your Lordship, I have come before Your Lordship on one FIR. That is 4/12/23 FIR, which is today. But Your Lordship, in this, there are 3 FIRs, FIRs in which they have improved the FIRs. Like in one FIR, they have on 4/5/23, she has filed an FIR. And again on 26/5, she has filed an affair against the same person, your lordship. And again 4/12/23, she has filed an affair.
Same.
Same content, but the sections and allegations are different. In one,
Little improvise.
yes, your lordship. So your lordship,
The main allegation 370 has been has granted by the
yes, your lordship.
continuous affair in different story.
Your lordship may
Indicating
also,
the original cause of action in the date 14/5 they 14 से argued.
your lordship in all.
Just simply issue notice let us.
Yes,
Your lordship, one more prayer, your lordship. Your lordship may hear these three together. So
Together means the,
all the.
where are the other? Give the
other
numbers.
two I have, I'll
Give the
your
numbers.
lordship.
Give the numbers. Huh?
And one more
Yes.
request, your lordship. In that 376 matter, your lordship, tomorrow the lower court is going to frame charge. I may be permitted to take an adjournment, your lordship.
Say এটা সেটা কোন সেটা তো
Eta nahi aji, that matter is not there.
How can I pass order which
Your
is not
lordship.
before me?
Your lordship, but it,
has
I'll just issue notice and tag without.
yes, yes, your
I
lordship.
can't pass the order there. Yes, because that FIR is not subject matter. of this.
Yes, your lordship. That is the reason I have
Issue
mentioned.
notice, to opposite party number three, and soon to accept notice for 1 and 2, or tag the BC matter along with it. Yes.
Oblige, your lordship.
14.
My lord.
Yes, sir.
Well, prior to filing this application, a CRMT application was disposed of by the Hon'Ble Court, page 13. My lord. As
Yes.
Lord counsel, the petitioner seeks to withdraw this petition and to raise all the technical points before the court below. According to the CRMT stands disposed of as withdrawn as platform. Therefore, we may approach the Lord Family Court cutoff. Family Court, my lord. Sure, page.
family good.
What are you challenging now?
Though the order has been passed, Annex 4, page 16, ma'am. On the basis of order passed by this Hon'Ble Court, we have filed this petition.
Yes, yes.
Annex 4.
Yes.
Therefore, said application was disposed of and merit.
Where is that order?
No, my lord, Annex 4, my lord. Annex 1, my lord. Not obtain the certified copy, my lord. That is the problem.
The order is not there. How will it?
The copy मिली lower court proceeding जाऊ 24 तारीख रखी वो तो copy टाइप होता मिलनी Annex 1, my lord.
The order which you are challenging, the order has to be placed before court. You have applied
Man,
for
what-
it, so we wait.
Already applied, man.
Let it come then.
Lower court proceeding, man, state, man.
No, how can I say? I don't know. What is the order?
अरे कॉपी टा मिले ना मो व्हाट्सएप लाइव दो आया
ଆପଣ ଇମ୍ପିନ୍ ଅର୍ଡର ଆପଣ ପାଖରେ ନାହିଁ ଭଲ କଥା ଠିକ
ସେଟା ଆମର ସାର୍ କଣ ଦୋଷ ଅଛି ଆଜ୍ଞା
ମୋର ବି ତ ଦୋଷ ନାହିଁ ମୁଁ କଣ କରିବି
ମୁଁ କଣ କରିବା ପାର୍ଟି ଆଜ୍ଞା ସଫର ହବ
You have to show me the IMPIN order. I'll put it Monday. I'll lease it at Monday. Lease it. Get the certificate copy. Go and try and get the certificate copy. If not certificate copy, at least uncertificated copy.
ଆଜ୍ଞା
And file an exemption application from filing certificate. copy.
Monday.
Okay. Monday. Yes.
15.
Yes.
Present petitioner is the registered owner of the vehicle.
Register?
Registered owner of the vehicle.
Okay.
File Annex 1 as at page 24.
Show me the IMPIN order.
Impugn order is Annex 9 passed by Learned Additional Session Judge.
Yes.
It starts from page 61, 70.
It is in revision, huh?
In review.
Yes.
The fact of the case is there is an agreement between me and OP2. I handed over my vehicle to him on the basis of the terms and conditions of the
Agreement.
agreement. Lordship, I will draw your kind.
You tell me, I need not.
The terms and condition was during handing over the vehicle, he had given me 4 lakh, total cost was fixed at 9,70,000.
Part payment he has made and taken the car. Okay.
With the terms and condition that balance, that vehicle was under hypothecation. Balance EMI, regular EMIs he will pay. Otherwise, again the term condition is, if he fails to pay the EMI more than one, I have the liberty to take repossession from. That is the condition.
Okay.
Accordingly, he did not, he failed to pay the EMI. Financer seized that vehicle. And he did not choose to take any step from to release that.
Financial, yes.
I filed a consumer case before the Telangana District Court. There the order was passed by the Consumer Court that I will deposit the defaulted
The
amount.
remaining amount and take
That
it.
vehicle will be released
Given-
in my favor.
Yes.
That was done. Just the order was on 5th January 24. Next day, I deposited the money and got the vehicle released from finance company. Just after 7 days, the OP2 lodged an FIR against me that I have taken his vehicle. Because he was
The owner, on the basis of that agreement.
I was owner.
On the basis of that agreement.
Bus agreement. That on the basis of that.
Then you move an application, that was seized.
On the basis of that FIR, the vehicle was seized from my possession. I moved on 457% seeking release, and he also
Allowed in it.
Intervention.
no, both the 457 petitions were rejected by the learned magistrate. I prefer revision before the learned session judge. Session judge allowed my revision and directed to release the vehicle.
So what is the problem now?
Release the vehicle in my favor. He came instead of the filing revision before the session judge, he came before this honorable. This honorable court set aside that rejection order and directed to consider his 457. Lord Magistrate release that vehicle in favor of.
Then there is two release order. My state says release in favor. Revision court says that release in your favor.
By law session.
At least you notice.
Now what happened? Against that release, I prefer revision again before the session. The session judge has confirmed that.
Against that you come. At least notice. At least let the other side come. Because there are contending claim between two of you. Have you implemented him as a party?
Yes, I implemented.
Respond no to issue notice and so on so accept notice for. Yes.
And I have already closed that loan EMI. My vehicle is.
Why don't you return the advance money which you have taken from him? Pay and become some money you have taken, 4 lakhs you have taken already.
Yes.
From him, you have to pay it back.
Let him return my.
Let him come. You come with that 4 lakh rupees, you pay and get the vehicle. As simple as that. You come with that money next time.
That is the cost.
Next. 4 lakh, see, agreement is there. 4 lakh you have taken admittedly.
Yes.
Somehow he has not paid the installment.
Yes.
You paid the installment subsequently. You pay back his money and you become absolute. As it is, you are on it.
That's true.
Yes, next. 16.
Please, my lord. My lord, here the petitioner is the owner of his truck. My lord, the said truck is also seized by the Nandipoda police station with an allegation that I am lifting the sand from the river Boitarani. That is there. Only, my lord, my prayer is to release the vehicle pursuant to the order passed by the division bench of this honorable court in dealing with all the provisions. My lord, only to save the future further. Only to save the future damage of the vehicle as well as the not to put burden to the borrower who is also
Where is that order of rejection?
Rejection is not there, only the FIR is there. Because pursuant to the order.
Have you moved application under 457?
No, that is PI guidelines. Sir, guidelines is there, sir. That is
my judgment is also there. I have also given a guideline.
Justice party in the vacancy.
My recent judgment 2 months ago.
Only, my lord, my prayer is with that.
The court will come to your house to give you?
No.
Then
Only-
you
only
move
my-
an application.
Sir,
Where is
sir,
the application?
Sir, only my prayer is that a direction me
We
issue.
can't preempt a procedural application under 457. You have to move an application.
No, sir, please see the order. Please see the order. The
I know
guidance.
why.
Sir, guidance, sir, guide specific. He has also
Land
the
counsel for the-
honorable division.
Land
bench
counsel for the
also-
petitioner.
Section
1 minute. Land
Sir.
counsel for the petitioner seeks to withdraw this petition to move appropriate application before the trial court for release of the vehicle, relying upon the judgment of
division bench
this
decision.
court,
Yeah.
relying upon the judgment of this court, recent judgment as well as the judgment of division bench passed in WPC number
316
22 of 2021. Ashish Ranjan Mohanty versus State of Orissa. If such application is moved, the same shall be considered on its merit.
Sir, obligation.
17.
My fruit. No, I'm challenging
Can't
the,
express any opinion. Yes. Yes, sir.
also may see that is 50 lakhs government money has been misappropriated. 50 lakhs. It was transferred to my account from Bhubaneswar to Berhampur. That is there in the record. But Lordship may see the inquiry report, page 27.
27, huh?
7.
Okay.
My lord, the mastermind in this case, my lord,
Mhm.
OP8, DDO himself. He sent the money
Mhm.
to my account
Yes.
and would the said amount which has been come in account in my account, but to whom I have paid,
Hmm.
that was not on the any record. Mo account କୁ ଆସିଲା ମୁଁ ଦେଇଦେଲି.
Now, what are you
But,
now?
then I am coming to. 20 inquiry also reveals that Manoj Jena, peon of that my lord, that office, that is Directorate Health.
Now, let me understand what are you challenging?
Yes.
Cognizance of entire proceeding.
No.
And then,
Further investigation. I want that further investigation because of your lordship may see the.
where have you said that for the?
Yes, ma'am. That is
Further
my-
investigation.
Yes, my lord.
Basing on Annexure 3.
Yes, my lord.
Very
That is
The prayer
the
is just
report
to
of
quash
the CIDCB.
quash the charge sheet and cognizance, both.
The submission of inquiry report on the
Then
petition.
your prayers are contradictory.
My lord.
Your prayer is contradictory. You say quasi cognizance. You
Like,
say
no.
and further investigation.
My
Also.
lord, the basing on which the cognizance has been taken, that inquiry report is not correct, your lordship. Basing on this, your lordship may see.
See,
Tonkata is the admitted fact, but some account
the investigation is a prerogative of the police. I can't guide.
My lord,
You
this
read
is
this, you read
my
that.
lord, by basing on my information before the authorities from top to bottom, my lord,
Hmm.
this inquiry report says I am innocent. Your lordship may see that. OP8, your lordship may see the conduct
This
of
can
OP.
be used. This document can be used in your defense.
मतलब trial हेले कौन हबो मो account गला money has been recovered from other persons 33
All
lakhs
these things are correct, but technically, what can I
457
do? For
हजू
you?
से मैंने भी नहीं गलनी पैसा.
But technically, what can I do for you? Now, see, the problem is there is cognizance order.
Yes,
And you want that a particular document which is in your favor should have been taken into consideration by the police, which he has not taken. into
Yes,
consideration. That's the whole.
yes, that
is this thing.
and conduct your lordship may see the conduct of OP8, the DDO himself. Again, लोको सही पियोन को से पठाई मोर ड्रॉर चिरी नहीं that is the.
What is the stage now?
किछ नहीं सिन पड़ी
Cognizance. नहीं, that is
किछ नहीं आज्ञा सिन पड़ी तो लोको आज्ञा तो माने जाई प्राइम मिनिस्टर लेवल जाई लेखा पठाउची इंक्वायरी चलछि. Your lordship may see that.
Subject to
Inquiry, your lordship may 27
Page-
times just placing.
Page 12 make an glance.
12.
Once there is an allegation that he is
Manoj
being the
Jena,
accountant,
kindly see.
being the accountant is the custodian of the check. How the check has missed is essentially shoulder on him to explain.
That this is the thing your lordship
Can you
may
say that to
see.
the peon and Allah, magistrate,
Collusion
authority?
conspiracy with Manoj Jena removed the checks. Your lordship may see to page
Who is the
27.
custodian of the check?
I understand. ଟଙ୍କା ମୋ ଆକାଉଣ୍ଟକୁ ଯାଇଛି କେମିତି ଯାଇଛି ହଜୁର ତାଙ୍କର ନିଜର ବ୍ୟାଙ୍କ ଅଛି
All these things.
that has been sent.
Perhaps I can't go into all this.
My lord, this is a conspiracy made by the DDO himself.
Maybe, but
If-
police
if
has
That
now-
is there. That's why, my lord, investigation has not gone to them.
And
Because
if
of
the
these people,
petitioner
let me see this.
desires for the reinvestigation, he may separate payer. by quashing of a paper and
No,
tax
that
deduction.
the prayer is contrary.
If you contrary prayer, how can one in one hand
unless
is
it
saying
is
that
being-
it has to be quashed?
Further-
You should emphasize
Yes, ma'am.
on
Yes.
further investigation
My lord.
by moving appropriate
After
application before
application.
trial court. A trial court feels
Trial
it.
court is also without not
I'll give
without
that to
jurisdiction.
Yes, ma'am.
Let him go and move on
Yes,
application.
yes,
in
yes,
trial
Yes,
court.
yes,
Yes.
there is a quorum.
See, the petitioner is by invoking the inherent jurisdiction of this court, exploring the following relief. Exploring the following relief. The relief sought by the petitioner appears to be contradictory in the sense that the petitioner, in one hand, seeking quashing of the cognizance order, at the same time seeking further investigation. When the petitioner confronted with the such situation, he prepares to withdraw the present petition to move appropriate application before the trial court, seeking for further investigation.
Basing on the crime batch report.
Basing on the document,
Yes, ma'am.
the document
No, that-
as has been relied upon by him in this petition. Without expressing any opinion on the merits of the case, if such application is moved for the trial court for the purpose of seeking further investigation, the same shall be considered without the same shall be considered on its merit, on its merit. With this liberty, the petition is disposed of. You move application because your
Yes.
prayer is
No,
contradictory.
no, my lord, until it is being quashed, how the further investigation will?
No, 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 no.
Not necessary.
Not necessary.
Not
Quashing.
necessary.
That's-
The magistrate is not powerless.
Of course.
Whatever documents have come,
Yes.
it has come.
Yes.
Some
Further
additional documents
investigation.
have come.
Yes, yes.
The
So,
magistrate
that
is
is-
not
that is the-
powerless.
You
That
can't
is-
say that let the
My
case
lord,
be quashed and
one-
after further
That,
No,
that
no.
is, that is the crime branch report. If it will quash, then I may be.
We don't know
Yeah.
what happened. You move
My
application.
lord, this is in a clandestine manner. Didio himself has done this crime, my lord, because your lordship may see that. See that lordship may annexed to the.
I have seen it.
Kemi said, गाड़ी रे
You may be correct. I am
काठा लोड
not-
करी नहीं गले ड्राइवर जानी
You may be correct. He is also with you. But all these things, all the technicality has to be sorted out. You move
रेस्पॉन्स
up.
एम्बुलेंस से काठा लोड करी से नहीं गले ड्राइवर does not know about this time.
There are many stories which is not reflecting in the record. There may be a story against you also.
No, that your lordship may DO for report lordship have a glance to that.
Okay, it's all right. Now you move up.
That,
Yes. 18.
Item 18.
18. Anybody?
The affair ignored on the ground of fake certificate obtained by the petitioner. The matter is required to be investigated.
Fake certificate.
Fake certificate, page 16.
Further verification has taken place.
Less that one Dhirendra Kumar Digal petitioner obtained fake BED certificate with the intention to an opportunity engagement in service. Yeah, at the outset, it cannot be quashed.
Yes, sir. What do you say? Mr. Samantray.
Got apartment as
Let's see.
petitioner got apartment on 22/1/2013 after a due verification of the certificates by the district collector of Bauda, and after 6 years, the DO, district education officer of Bauda district, after due verification also recommended his name for permanent appointment, and the director of secondary education also confirmed the petition's appointment after due verification of certificate. The subject matter of dispute is that the mismatch of a registration number. In 1995, there was a facility for the students to take a private BA from Utkal University. And the petitioner has submitted all relevant documents, his degree certificate, form of fees, and got admit card and appeared examination passed out. And this was confirmed by 3 levels. First at the time of appointment, second at the time of district education officer level, while his name was recommended for regularization, third by the director of secondary education. After
Come
elapse of 10
to the
years,
point. All this story will
the
not
block
help you.
education-
All the story will not help you. Come to the point. The fake certificate you have produced, whether subsequently it is verified, whether it is it is genuine certificate.
Please see, my lord, please see, my lord, please see page 27.
27. Okay.
Sir,
Yes.
when the to Inspector Nalina Das. Sir, when the IIC, who is the IO of this case, asked the Utkal University to produce the fee register, the admit card register, the mark list, etc., the Utkal controller of Utkal University submitted him that those documents are not available as all are burnt during student registration. But this report has not been reflected in the charge sheet by the IO. The charge sheet is suppressed this information and submitted charge sheet because this case, this FIR is lost by the government
The
officials.
records
So,
of the
by
university
the-
You have to
Okay.
open install para 5 mechanical glance.
Para
Even though documents are given him born by
the university.
the university.
University office.
But
Yeah.
the record shows that how can the name and registration number do not tally with the university records. Records is there. Some of the document may have been lost.
My lord,
Yes.
It is required to be
He
input.
got his job in as a teacher.
Yes, number of
I have to
teachers,
submit.
number of persons,
Okay.
number not only this person, number of persons. There is in other areas are also like this. So distance education are also like this.
Distance education in few cases they got
Andhra-
certificate that these are genuine certificates.
Later
On that basis, you have reinstated them.
here is
You have
the
watched a couple of matters.
in our university, Utkal University records.
This is
The
Utkal.
name and the registration number do not tally with the university.
Just check if you can, we can
Yes.
help because he is a teacher. If you can
Yes.
help, if something can be done.
Yes, yes.
Okay. Issue notice.
I have to
Yes.
submit that. I am to submit
Yes,
that
yes.
during the
I issue notice. Let us examine.
There
Yes,
is no
90.
provision to reflect the registration number.
We'll see. Yes.
19.
Ninety. Non-APS in the interception said yes.
20.
20 may please. 20 may please.
Yes.
19 adjournment.
Nobody. Yes.
The matter has amicably settled between the present petitioner and victim, and the present petitioner married to the victim, let's see. And he is present, and the said my friend is appearing from the informant, let's see, victim.
Section 6.
On the same light, I have supplying the case laws copies, let's see.
May relied upon your lordship's judgment.
Matter victim is present. He has no objection if the
What is
criminal
the age of the boy?
is now in FIR and body of the FIR, let's see, 17 plus, let's see. Now 19 years, let's see.
29.
19 years.
Who is the informant?
Informant is he is appearing, she is appearing. Informant is victim there.
No. What about the parents?
He is the informant, Melchi.
No, but she is minor. Must be parents are also.
Filing the question of DV miscase of the present opposite party, madam.
Sorry?
DV miscase 136 of 2024,
DV miss case.
madam, page number 23.
Matrimonial dispute.
Matrimonial.
I'll issue notice.
My
Okay,
lord.
issue notice.
22.
One thing.
Madam,
If you miss the FIR, player is the FIR.
Affair?
Item 22, the
21.
21.
Madam,
JMF sheet pending DV miss case number 136 of 2024. It's matrimonial. Yes.
madam,
Yes.
madam, may I pray one thing? Miscase is there, madam.
It's all right. Issue notice on this case. Nothing.
Madam, July 7th hearing by for that.
Yes, next.
22.
Madam, may I pray one thing, madam? No, kindly send my mediation center, madam. Newly married couple.
You call them, let us see.
New
Let us
married
see.
couple.
I don't know how many cases are there. 498 cases are
Yes,
there.
498 cases.
So let will you please serve the notice and let them come. I'll send it to mediation. Yes.
Till then, madam, kindly stay the matter.
Yes, next.
22.
Oblige that.
May I brief? There is a dispute, civil dispute between petitioner and opposite party number 2 related to purchase of a land. Actually, petitioner number 2, opposite party number 2 had given some money to purchase a land of the petitioner. Subsequently, she did not register. That is where dispute arose. In the meantime, he has returned back the money and matter has been dispute has been settled. Now, I filed this case for quashing of the FIRs.
settlement at the end. Settlement at the end.
They will appear and file affidavit here. Any date next Thursday, we will also ensure that she will appear in person.
Simply issue notice. The land council for the petitioner submits that the dispute is arising out of a sale consideration. The dispute is arising out of a, the FIR is arising out of a civil dispute regarding a land dealing. The money paid for the purpose of purchasing of land has already been returned. And the parties have settled their dispute. However, the terms of settlement is not placed on record. Therefore, he seeks an adjournment. At the same time, he also prays for issuance of notice to the opposite party number 2. Issue notice to opposite party number 2. Liberty granted to the petitioner to file the settlement terms, joint settlement terms before this court by next date of hearing. Is the matter. Yes.
Possibly fix it to next Thursday so that I will ensure.
Next Thursday. Yes.
20th. Belgium. 24.
23.
29. Let's see,
Adjournment.
May I please? Belgium matter, my lord. NBW order dated 3/10/23, my lord.
Bail. When you got the bail?
Bail, my lord. Bail order dated, my lord. Bail. 16/12/2020, my lord.
16/12/2020 bail. And
Bail.
NBW 3/2/2023 2023 ठीक है 15 जुलाई तो all 15 जुलाई ठीक है okay 500 yes
25.
no high court bar code yes no I'm quashing it subject to payment of cost of 500 rupees and appearing before the court and resorting to the remedy available to him under law. NBW. Yes.
25.
NBW issued on 3rd April 2025. Bail 15 December 2016.
15 December 2016 and NBW 3/4/2025 500 yes
26.
26, my lord, this is a Belgium matter, my lords. NBW is issued 4/4/2025, my lords. Petitioner swear on bail, my lords.
Dates you have?
Date was not there, my lord, but petitioner swear on bail, my lords.
Petitioners, counsel for the petitioner submit that all the 3 petitioners were on bail.
3 persons, 3
petitioners were on bail, but for their absence from the court proceeding, NBW was issued on 4/4/2025, 500 each.
Obliged, my lords.
Yes.
27.
My lord, I am in BC. NBW was issued on
2017
7/2/2025.
No. Annex 1 just see. Annex 1 25, 7/2/2025.
Sir, my lord, 25. Master develop.
You are on bail.
My lord.
Both of you are on bail, huh? You give the date when you got the bail?
Sir, previously I was, this is a case number 2023. I was on previously police bail and thereafter subsequently released on bail by the court. But there is no specific date.
They were in bail and NBW is issued on 7/2/2025.
25, sir.
500 each call.
28.
Obliged.
May I please your lordship? My lord, NBW order 09/2/11/2017. LDR bail order 12/7/2017. Order number 4. Page 7.
Yes.
My lord, NBW order 09/2/11/2017. LDR bail order 12/7/2017.
When you got the bail?
My lord?
When you got the bail order?
Bail, LDR bail order thila 12/7/2017 my lord.
27 2017.
7/2017. Answer 7, page 7.
You tell, madam, you tell. What?
Page 7.
No, tell the dates.
27 2007.
Date my lord 20/7/2017.
Can you please wait? When you got the bail?
27 2017.
27 2000 bail. NBW on 2/11/2017. 2/11/2017. Let it be 2000? 1500. 1500, huh?
Yes.
Cost 1500. Yes.
29.
They could be more than one PO each. Yes.
Yes.
Yes, madam.
This is a Belgium matter, and date of NBW was issued on 25 2024.
Yes.
Cooperating since 2016, and this matter is pending for charge. Let them cooperate. The matter is pending since 2016 for charge.
They will appear on or before 15th of
Yes.
20/5/2024 NBW, and you were on bail.
Yes, sir.
On bail. Have you do you have the date when
No.
you got the bail?
No, my lord.
Okay, 500. Okay.
30.
My lord, NBW issued on date.
In 4/25 day. No further extension. Yes. Yes.
33.
May I please, my lord, warrant has been issued on dated 2/3/2023. The petition was on bail since 16/10/2015.
Okay, 500.
That is page 70.
16/10/2015.
15.
Bail.
Bail
2
and
3
warrant
2023.
2/3/2023.
ठीक है?
2/3/2023. Obligement.
34.
May I please, my lord? Bail granted on 6/7/2017. NBW issued on 18/2/25.
500.
35.
And NBW issued on 27/3/25. Earlier, the petitioner was on police bail, my lord. Under annexure 2, I have annexed the copy of the charge sheet. The relevant page is page 17. It was reflected, my lord.
The petition was on police bail, huh? Police bail. NBW 27/3/2025. 500. Yes. Yes.
36.
My lord, the NBW was on 16/7/2024, and the petitioner was on bail on from 16/11/2020.
Got it? 500. Yes.
37.
NBW issued on 16/2025.
Page 12.
Yes.
Page
You're
12.
on bail.
Bail.
All three.
I mentioned that paragraph 3, madam.
Paragraph 3.
Yes, ma'am.
Paragraph
4, ma'am.
Paragraph 4. Okay.
They are granted as the anticipatory bail.
500 each. Okay.
38.
May I please, my lord?
Yes.
My lord, the petitioner was released on bail on 14/11/23. Relevant page is page 24.
Okay.
And NBW issued on dated 10/4/25.
500. Yes.
39.
May I please, my lord?
Yes.
Lord, here NBW issued on dated 23/4/2024.
Yes.
There are 41. May I please your lordship, my lord, 41. Am I audible, my lord? Am I audible, my lord?
Fifteen hundred to be followed. No further extensions are granted.
16
Yes, yes.
42.
41, my lord.
May I please, my lord?
Yes.
My lord, NBW issued on 8/4/25, page 23, my lord.
Hmm.
And they were on police well, my lord. It was also reflected on the order.
Three of you,
Yes, my lord.
500 each.
43.
May I please? Here, my lord, the petitioner was released on bail on 27/1/21. Relevant page is page 27, my lord. And NBW issued on dated 19/4/25. 317 petition filed and it was rejected. And thereafter.
The case before trials. 44. Yes,
All
Lord, NBW dated 24/6/2022. The petitioner was on bail by the order dated 12/8/2013.
13, okay.
But in the petition, my lord, I have wrongly mentioned as 8/8/2013.
Okay.
It is
1,000.
Mine.
1,000. Okay, 1,000. Yes.
45. 45, my lord, there are two petitioners. The common order of NBW dated 21/3/2025. And the petitioner was granted, petition number 1 was granted bail on 7/4/2020. And petitioner number 2 was granted bail on 4/12/2019.
Okay, 500 each. Okay.
46.
Adjourn.
47.
For modification of lordship's order, while your lordship granted bail, kindly see condition 4. He shall be released on bail subject to verification of antecedents beyond the cases already disclosed. By the filing of this bail application, 7 antecedents are there. While we filed the bail bond, when the report called for by the learned court below, it is found the case is 15. The all remand case. So it is till today also, well, kindly consider, till today also, it is very difficult to know that how many cases they remand against me. We are the agent. It's a cryptocurrency. We invest public invest the money. Not a single rupee in my account. All account in the original company. And they are not control the original director who received the money. Not if single money received from the customer in my account or by me, then I have no case. But all in the remand.
The problem is you file an affidavit.
Yeah,
On the basis of affidavit, I have said.
Yes, that's correct. My lord, till today,
And then the wrong affidavit.
what I submission, my lord.
Investors are there.
Huh?
30 to 40 investors are there.
So all are cryptocurrency. They invest the money. After 2 years, when they do not get back the money taken by the person who residing in Rajasthan. To that effect, they have not investigated till today. Not yet apprehended.
There is more of a reason that you shouldn't get bail.
My lord?
More of a reason that you should not get bail. You don't know how many cases you are involved. After you get
how many investors?
How many cases?
All the investment by the public to the entire to the company, not to me, not at all, not a single case.
Again,
but here, they
I'll
all
just issue
remand.
notice verify how many cases are there. Issue notice. on the application. The state council is to verify the antecedents of the present petition. At least you come to know how many cases are there. Let them make.
And that is the remand. What I mean to say, my lord, let me clarify the remand case. That is the only.
How many cases are
Yes,
there?
ma'am.
At least you will come to know.
Yes, I also come to know.
Yeah, that's better to know. At least.
My lord,
Yes.
like,
Let
all
them verify.
three cases are there. 46,
47, 48, 49, na?
My lord, oblige, ma'am.
All the three cases, right? Which case issue notice to the state council accept notice, and the IO of the case is to verify the cases, antecedent, and file an affidavit to.
My lord,
Yes.
oblige.
Yes.
Serial number 46 is not placed, sir.
Which one, sir?
Serial number 46.
46 not placed.
My let's pardon, my shall I pray one, my
50,
pardon,
50,
I
50.
50, my lord, I pray for a short modification of your lordship only with regards to the condition 7 VI. 7 VI, my lord. It was inquired by the London magistrate. There was the antecedent, 3 antecedent against petitioner number 2, 1 antecedent against petitioner number 3. My lord, the petitioner number 2, your lordship has categorically stated they shall be released on bail subject to verification of the similar type of antecedent. Petitioner number 2 is another offense, my lord, price sheet fund. The London magistrate said that since it is similar with this SOTA case. And petitioner number 3 is just only one SOTA case. They are they have been released on bail in all these cases. Then I pray, my lord, since all the petitioners have granted the benefit, as your lordship was pleased to dispose of all the allowed this bail application, an additional your lordship has observed categorically in the coordinate was granted 438 and 439 in this similar nature of case in similar location, other cases. So I pray, my lord, also any additional condition in lieu of that, I am ready to abide.
Page 5.
हम तो कही थी
One minute. Page 5 of where application.
ना जो rejection order.
Where is that?
I mean, I have also.
Yes, yes.
Have similar type of antecedents to that of the present case. The Hon'Ble High Court of Orissa also pointed out in para 7 that they shall be released on bail subject to verification of similar type of antecedents. In obedience to the order of the Hon'Ble High Court of Orissa in letter and spirit, as the accused persons have similar type of antecedents, I am trying to bring.
Naturally rejected. Where is your application?
My lord.
Application for modification.
Modification, my lord, IN number 678.
You just check it up. How many cases are there?
No, my lord, I have got the information. 3 cases, it is the order category.
Let him verify. Issue notice on the application 678 of 2025. The state council accept notice and to verify the antecedents of the petitioners in the case and file a report to that effect. Please the matter on Thursday.
My lord, may I say one thing? Already the London PP in lower court and as well as the London magistrate called for the report, entire report they have perused and
in this proceeding, let the procedure be conducted.
Yes, as your lord.
Yes.
Pardon, may fix a date. He is in custody.
Yes, yes.
My lordship, pardon, my lordship, item 20, my lordship, till Thursday matter has been listed. Till that, my interim protected, my lordship.
No. Let's see. I have already. Yes.
My lordship.